some of the clients are very keen to get on with the dispute and to skip those steps. But they do so, I think, with the risk that it may be found that their claim is not admissible simply because they haven't gone through the prerequisites to bringing the claim in arbitration.
Very interestingly, it's funny, but a couple of years back, I remember coming across a case which I had read, thankfully wasn't involved in, where a notice of arbitration had been held to be invalid by the court because despite the various details in the notice, counsel had forgotten to state that they were invoking arbitration.
So, hi everyone, welcome to Arb You Listening. This is a podcast where we dive deep into the world of arbitration. It's a series dedicated to bringing nuanced and diverse perspectives on arbitration to practitioners across the globe. Whether you're a seasoned counsel or just starting your journey in arbitration, this podcast will offer you valuable insights from top experts in the field, trained in various jurisdictions and legal systems. Each episode will feature discussions with experienced arbitrators and practitioners, sharing their knowledge and practical tips to help you navigate the complexities of arbitration. So whether you're here to expand your knowledge, to refine your skills, or simply stay updated, Arb You Listening is your go-to resource. So thank you everyone for joining in. This podcast is an initiative of the India Arbitration Group of the ICC India. My name is Anchal Basoor. I'm a counsel practicing in dispute resolution in New Delhi. And I'm also the secretary for the ICC IAG. Today, we are going to be discussing something called the Notice of Arbitration and how pivotal it is in the whole arbitration process. Very, very secondly, it's the first document that really goes out from your lawyers. It's the first document that sets out your position. It establishes your conduct. And frankly sets the ball rolling for the proceedings that are to follow. Many national acts provide for this document, how it should look like, what the form of this document should be, and more or less it is also defined by a lot of institutional rules. So we would be speaking about the Notice of Arbitration today, what it is, why do we need it, and what is the strategy you need to actually send this document out. Joining us today as a moderator with me is Ms. Shruti Sabarwal. She's a partner with Shardul Amarchand Mangaldas in their New Delhi office. Shruti regularly represents and advises clients, both private and state entities, in commercial arbitrations and litigations. She has acted for Indian and foreign parties in arbitrations seated all over the country, in fact, and also in Paris, Dubai, London, under various institutions. She acts for clients before various fora in the country, including the Supreme Court, the High Courts of Delhi, Bombay, Bangalore, and even Ahmedabad, besides others. Thank you so much, Shruti, for joining us today. It's a pleasure to have you here with us.
Thanks, Achal. Pleasure to be here.
Thank you so much. And our speaker for today and our prestigious guest is Mahesh Rai. He's a director of dispute resolution with Drew and Napier in Singapore. Mahesh has a distinguished career. It has spanned various sectors such as technology, construction, infrastructure, telecommunications, shipping, energy, and commodities. He's a counsel for choice for litigation and arbitration matters, which are complex and high stakes. In fact, I was just joking with Mahesh right before we started that he has been consistently ranked in several leading publications. If we start to go down the road to naming them, I think the length of this podcast will be consumed. So I'm going to skip all of that. He's been consistently ranked as the top lawyer by Legal 500, Chambers and Partners, Chambers Asia Pacific, you name it. But what I do like to mention is that he has been recognized for his exceptional skill in advocacy and sophisticated legal acumen. As far back as 2021, he received the prestigious Joseph Ginsburg Outstanding Young Advocate Award, a prize awarded to the most talented young lawyers in Singapore who have demonstrated outstanding qualities in their professional work and ethical standards. I am so happy that you could join us, Mahesh, today. And thank you so much for helping our listeners understand this strategic aspect of an arbitration. Thanks so much for joining us.
Thank you, Achal. I'm pleasure to be here.
Thanks so much. So I think before we begin, my first question, or rather how I would, want to start our conversation is really by discussing what are the initial first steps as to when a client approaches you, Mahesh, with a dispute that, of course, has arisen already. There is an issue that they are facing. They have their contract, where sort of this dispute arose from, and they have approached you as counsel to give them advice on, yes, we want to proceed further in our dispute. Please let us know how to go about it. So, what is really like the first couple of steps that you undertake when you advise a client when they have to initiate these proceedings?
Thank you. So if a client approaches you and tells you that they've run into a spot or problem and they want legal advice from you, I think if the dispute is a contractual dispute, of course, it stands to reason that you would examine the contract first to actually match up whatever the client is telling you in terms of the facts with what the contractual provisions are. And you would allow the client to tell their story and get it down, hopefully in a chronological fashion, so that you can actually make sense of what is happening and really look at what are the claims that the client wishes to bring and whether that's borne out by the contractual provisions or the law. And of course, you would also very quickly check what the dispute resolution clause is, right? Because if the dispute resolution clause says it is in a foreign country, in the courts of a foreign country, that you're not qualified, then you should do the right thing and tell your client to go to a lawyer in that jurisdiction, as often happens. But if it is an arbitration clause that is provided for in the contract and something that you can advise on because you regularly do arbitration, especially with that specific governing law or a governing law that you're familiar with, then obviously you can take it on. But yes, so you would understand the brief nature of the dispute from your client, gather the facts, and try to compare that against the contractual provisions and see whether their cause of action is borne out or not.
Fantastic. I think that's really important, because what you did say about what the client is telling you and whether that dispute actually is borne out from the contract is really important, because sometimes those two are very divergent things. And once you look at the documents is when you realize. Shruti, I want you to sort of quip in here. We do have multi-tiered, dispute resolution clauses, and that does find mention in a lot of sophisticated contracts now. So when, what is the approach that you follow if you see a clause like this? What are the different aspects in which you would like to consult somebody?
Yeah, I mean, in a similar situation, somebody has approached you, they'd like, to invoke arbitration. Honestly, before I even see what the contract is about, I go straight to the arbitration clause. And then I'll get to, okay, what sort of contract is this? Who are the parties? Really, all of that. And generally, it's always good practice to follow the arbitration clause to the T. Particularly, like you mentioned, there are several clauses which have, multiple layers in them. Sometimes just amicable resolution attempts are required. Sometimes formal mediation or conciliation is required. So it's important to advise the client that those steps should be followed. And only in exceptional circumstances where, maybe the other side is just non-responsive and has been so for a while, would we advise that you proceed to invoke the arbitration without actually following those steps. So it's very critical so that later, the other side isn't able to take any sort of technical objections to the manner of invocation for the arbitration.
Right. I'm curious, Mahesh, is this also the position in Singapore? Do you have to mandatorily follow all the tiers that are given in your dispute resolution clause? Like, for example, if there's a negotiation requirement, would I be, really pushed into following that, or can I straight away go to, initiating maybe the next step?
So in Singapore, about 10 or 11 years ago, in a case called IRC and Lufthansa, I think the Singapore Court of Appeal had a chance to examine a tiered dispute resolution clause, and they held that if there are pre-arbitral steps and if you don't go through that, then that is a jurisdictional defect on the part of the tribunal. So the tribunal is sort of robbed of jurisdiction. But I think you would see from the jurisprudence around the world that the debate has now moved from jurisdiction towards admissibility, right? So there's a dichotomy between the two of that. So the modern view now, I think it's accepted, pretty much settled that if you don't go through those steps, it affects the admissibility of your claim. Right. Interestingly, in a recent decision of the Singapore courts in Max Engineering, where there was a pre-arbitral step to actually try to mediate through negotiations, the court issued an order directing parties to actually mediate the dispute. So that was quite novel in that sense. So in Singapore, I think we do take the pre-arbitral steps pretty seriously, much as they do in the UK. And for that reason, I think you are well advised to try to at least jump through the hoops. Sometimes you're faced with clients who basically ask you, what is the point, right? Because they are confronted with a multi-tiered dispute resolution clause. First, the operations people must meet, and then it gets escalated to the manager, and then the CEO of the respective companies have to meet, and then you have to have a mediation before the arbitration. And so some of the clients are very keen to get on with the dispute and to skip those steps. But they do so, I think, with the risk that it may be found that their claim is not admissible simply because they haven't gone through the prerequisites to bringing the claim in arbitration.
And sometimes I think they also look to skip the pre-arbitration steps because they're concerned the other side is, taking action to maybe, do away with assets or things like that. So it's important to let the client know that there's separate measures you can take for each of these. But like Mahesh said, at least you should be able to show that you made all attempts, to ticking every sort of check off the box. Yeah.
Right. I think you find that a lot in the railway contracts here in India as well. So you have the engineer who have to approach, and then there's a conciliation and a mediation separately, and then only arbitration. So it's quite cumbersome as well in terms of, time and cost resources that follow. For example, now, Mahesh, that we've looked at the contract, we are going with the arbitration, we are going ahead. Where do you find all the applicable requirements? Like, so how do I really go about drafting this, first document? What do I look at? And where do I see all the rules that apply to me?
Yeah. So if you, depending on, what your applicable rules are. So if it is an institutional arbitration, your first port of call would be check the rules to see what the rules actually say about what are the necessary requirements of a notice of arbitration or request for arbitration. So all your major rules like the ICC rules, SIAC rules, LCIA rules, they will actually stipulate what is to go into the notice of arbitration. And most of the time, it is sort of a combination of, the names, the details of the parties, a reference to the arbitration agreement, which you're invoking, a brief nature of the claims that you're bringing, the relief that is being sought, and some indication as to the legal basis for those claims. And if your arbitration agreement provides for the selection of an arbitrator, you should also stipulate who the arbitrator is, or a proposal on how you want to appoint the arbitrator, whether it's sole or three-member tribunal. And then I think some rules also provide that you have to specify what the seat, the language, and the applicable rules of the arbitration. So there's some variation from institution to institution, but generally speaking, those are the key aspects of a notice of arbitration.
Right. And should one also be looking at the law of the seat when you're looking at, when you're drafting a notice of arbitration? Would that also have an effect on the format or sort of the, the ingredients of a notice? Or have you usually in your experience found that it's mostly the same, like the Lex Arbitri doesn't really say much about, what to put in?
Yeah. So I think I doubt very much that the legislation, whether it's an International Arbitration Act or otherwise, would actually go into that granularity as to what goes into a notice of arbitration. You would look at the institutional rules and see what requirements there are. And then, of course, if it is the ancestral rules, then the ancestral rules will actually stipulate what is supposed to go into that document. But otherwise, I think it's generally provided for in the institutional rules. And even if you're going under an ad hoc scheme, it is generally speaking, useful to hit to meet these requirements, right? To actually stipulate them. And each of those requirements, there's a purpose behind them. But we can go into that later.
Yeah, super. I think, Shruti, my question would obviously be ad hoc because this is what we usually, have to end up following in the Indian context. Would you agree this is primarily the format you follow when you send a notice of arbitration, or do you include more details considering the Indian Arbitration Act, section 21?
I mean, not really, because the legislation is fairly basic. It just requires you to invoke the arbitration. So, you know, just an overview of the, disputes, the parties, representatives were available, the arbitration clause, general sense of the claims, and that's it, your arbitrator nominee.
Right. In fact, this is very interesting. I've started to see this in the last couple of years. There's something called a composite notice of arbitration in the Indian context. I don't know, Mahesh, if you've seen this. So it's basically a legal notice, setting out your dispute and asking for a payment of whatever amount. And then there is a second section in that notice which says, you know what, if you don't end up giving me this within 21 days, then consider this as your notice of arbitration and consider this person as my arbitrator. And that's actually looked at as a valid notice of arbitration under Section 21. So, of course, that contains many more details as you would normally not provide in a standard NOA. But this is very interesting. We're seeing that a lot before the High Court filings, at least here in Delhi. So, it's pretty peculiar and an act of
That's quite creative, I must say.
yeah, you just, I think you end up saving a lot on the lawyer's piece. You send up one composite notice and you're sorted. So,
I mean, in one sense, actually, it could work. I mean, if you think about it, it's just, likely to be a lot more detailed, and you need to make sure, your contract, you're following your contract still, in the sense that, for example, if that dispute notice was supposed to be a cure period, you need to make sure that you've got all those ingredients mentioned. But I guess it could work, in some ways. Why not? Cost cutting.
yeah, absolutely. I found that very interesting. So, moving on from there, in fact, then the question arises is how pithy should my notice of arbitration be? What are the details in terms of course, we have the details of the parties, etc. All of that you take from the institutional rules. But most institutional rules will tell you that you need a brief statement of your claims or a brief description of, what the dispute is. So, Mahesh, I think your perspective on how detailed should an NOA be, and will I be, sort of showing all my cards if I make it a little too detailed? How much should I hold back? Your sense on this, please.
Yeah, I think it should be brief, but there should be sufficient details to notify the respondent of what your claims are and what the basis of it is. So I don't think that your notice of arbitration needs to be, unless it's a very complex dispute, I don't think it needs to be a very lengthy document. Most of the time, it hardly exceeds 10 pages or 8 pages, right? Which for some lawyers, surprisingly, is a bit of a challenge, right? Because they want to put everything in. But I think you have to toe the line between setting out sufficient amount of detail so that your opponent knows what the claim is, and also at the same time giving yourself enough wriggle room, because you probably haven't done a full investigation of the facts, haven't checked your client's version of the story against the contemporaneous documents or the law for that matter fully, right? Before you actually start the arbitration by filing the notice of arbitration. So for that reason, I think you have to toe the line between trying to be brief enough, trying to be pressé about it, but go into sufficient detail so that your opponent is not lost as to what the claim is.
And is it important to tell my opponent exactly what the claim is? I mean, is there so for example, if I am seeking, say, whatever, $100 million, and if I, in my notice of arbitration, set out that my claim is for that, can I later on in my statement of claim then exceed that amount? Of course, the rules allowed me to, but would it look like a bad positioning on part of counsel to do this?
I think that the notice of arbitration usually is an initial statement of what your claim is, right? Of course, it is ideal if your notice of arbitration and then your statement of claim, they mirror one another insofar as the monetary reliefs, the causes of action, and the nature and circumstances giving rise to the dispute, they are one and the same. That's the ideal position. Now, of course, there are situations where the notice of arbitration is simply a very brief statement that there has been a contractual breach and that my provisional estimate of my loss is this amount. And then there will be a reservation of the right to revisit this at a later juncture. So that gives you some wriggle room and to get it right, to flesh it out fully in the statement of claim.
Fantastic. Shruti, any NOAs that you've sort of, encountered, so for us, usually the first port of call is to check the notice of arbitration, the statement of claim, and if there are any contradictions, as a respondent, it's really nice to sort of start, your posturing with that, telling the tribunal that, they didn't even know what they were getting into. Anything that you want to share on this? I mean, what is your advice? How prepared should I before I send the NOA?
I think when you send the NOA, it's good to give a sense of the breaches alleged. I don't think you need to go too much into detail, as to exactly how the breach is made out, but you must at least let the other side know that, look, in terms of whatever has transpired, we are of the view that you have breached several provisions of the contract, and where you can and you're sure to be able to specifically mention those, it's always a good idea to do that. Uh, Inconsistencies, when you see it in the statement of claim, it really depends how inconsistent they are. I mean, if it's a polar opposite view, sure, you could maybe just raise it as an issue. Is it going to take you very far? No. I mean, it's mostly going to be prejudicial, unless it's something that's really, like on the face of it, totally contrary from what they said. Uh, Very interestingly, it's funny, but a couple of years back, I remember coming across a case which I had read, thankfully wasn't involved in, where a notice of arbitration had been held to be invalid by the court because despite the various details in the notice, counsel had forgotten to state that they were invoking arbitration. So it went as a notice with the breach and the loss and all of that, but they probably assumed it was obvious, but they didn't mention it. So it's technical things like that that the other side was able to pick up. And if I remember correctly, it was held to be invalid by the High Court subsequently. So they had to go back. So nothing happened. They lost a couple of months, but it's quite funny how it's these tiny things that can make a big difference sometimes.
Yeah, absolutely. I mean, also quite embarrassing, I guess, because standing in food, trying to salvage that situation. So I'm going to also now jump to my next question, talking about how prepared should one be. Mahesh, is there any I would say any situation in your view where I should be actually engaging experts right before even sending out the notice of arbitration? Have you ever done this, or is this something that you would advise?
So I think there have been occasions where we are going in for a big fight where we have engaged experts, and in particular, usually it'll be the technical experts, right? Who will provide a provisional view on whether or not you have a claim, whether it's for defects or you know anything relating to scientific or technical matters, so that you are fairly confident that if you were to mount the claim, it will actually pass muster. Right. So in those situations, it's usually advisable. There are also some situations where you would have engaged a quantum expert or a delay expert. These are what we call professional experts these days. And that's usually nowadays in the context of trying to get funding, right? So
Yes.
the funders want to know the merits of the claim, and not just the merits, but also the quantum. And so for that reason, you would see these professional experts being appointed to provide a preliminary assessment. And then I think the third situation in which that actually happens is where your client wants to make sure that they have their ducks in a row before they even start anything. But you're right, it's not frequent. And from my experience, at least in the Indian market, that's something that it's seldom done, right? So it's a practice that I think
Clients to get experts at the stage of statement of claim. So this is a distinct dream. Shruti, anything you have to say? Have you the Indian at once for Singapore seated, but never here.
No, I haven't, honestly. I don't think I've ever dealt with an expert at the stage of notice invoking arbitration. Um, Also, I do think that situation would be unusual where you would require it. I mean, just because there is an issue of certain technicality or there's a quantum issue involved, at least for the notice of arbitration, I don't think you may need to engage with experts. unless really the breach you're alleging, you're not sure if you can even allege the breach or even claim the kind of sort of provisional losses you're claiming without that sense. But I've never experienced it myself.
Interesting. That's interesting. I mean, this is interesting that Mahesh says that in certain technical cases. That's quite interesting to us. Maybe you can send us those examples later. But what I really want to talk about, and I think this is something that all our listeners will be interested in, is the second aspect of the notice of arbitration, which is, of course, you've detailed out your your claim, you've detailed out the dispute, and then you've you've sort of been given the task to now appoint an arbitrator for your client. Mahesh, how do you end up choosing the right fit? Is it and obviously does it depend upon the industry, the kind of dispute, or even the value of the dispute? So if you could just throw some light on what does the whole process look like how do you end up choosing someone?
So I think there's no one size fits all, right? So you appoint the arbitrator depending on the dispute that you have at hand. And the late Martin Hunter said it quite well, where choosing the right arbitrator, party appointed arbitrator in particular, is choosing, or even actually for sole arbitrator, choosing somebody who has the maximum amount of inclination in favor of your client with the least appearance of bias, right? So I think that's the maxim that you should go for. And if you have a case on the equity aspect of it, or the justice aspect, then you wouldn't look for somebody who's so black letter about it. If you have something where the contract's in your favor, you would look for somebody who's very black letter about it. Then there's cultural aspects as well, right? You would, if the project is in Asia, right, and particularly in the developing parts of the world, then you would obviously look for somebody who understands the cultural nuances of Asia. Not just people who say that they do, but people who actually do, so that when they're sitting and adjudicating this dispute, certain peculiarities, they may not be familiar with it, but they will not be surprised by it, right? So from that aspect, I think culture is important. And then, of course, knowledge of the particular system, right? So if you have civil law arbitration, for example, some litigants would actually start the tribunal with civil law qualified, all of them with civil law qualified arbitrators. Some would say, no, as long as the presiding is civil law qualified, or one of the three is civil law qualified, that is sufficient. You would also look at, for some disputes, you also look at industry experience, right? So shipping comes to mind, construction comes to mind, some types of insurance claims comes to mind. So you would basically cut the cloth according to what the dispute at hand is. There's no one size fits all.
Right. And how relevant is industry experience? Because what I understand is, and we did see that about 5, 7 years ago, is that, you were getting the same sort of appointments, even, whenever there were high stake arbitrations involved, you did have the same faces being appointed, regardless of the industry experience. So how relevant do you think that becomes as an arbitrator if you're doing mostly all construction cases in a construction dispute? Does that help in adjudication, or would you think that's not really that?
It depends on the dispute. So if the dispute that you have, that you're dealing with, deals with some aspect of the claim, deals with what the industry practice is, right? So for example, if somebody says, in this industry, it is customary for the contractor to do X, Y, and Z. In this industry, it is, all of this falls within the civil engineer's scope of responsibilities. Or that when you're seeking custom clearance, something happens, that might seem untoward to the unknowing arbitrator, for example. So for those cases, I think it would help if you have an arbitrator who has some experience, some familiarity with that industry. But in particular for very technical disputes, whether it's construction, whether it's shipping, or nowadays, whether it's technology, right? Cryptocurrency disputes. You don't want your arbitrator to be at sea when you're dealing with a cryptocurrency mining dispute, right? And situations like that have happened before, where you have, the adjudicator or the arbitrator is not very technologically savvy. That's fine, but has no interest in educating themselves, to that end. So I think the Singapore court judges are they've a very commendable practice. Even in situations where we have fought out cryptocurrency disputes and they feel like they don't understand the technology enough, they actually bother to read the white paper and then have a session where the lawyers educate them or the experts educate them, right? So there's some genuine interest in actually finding out how what the technical aspects of the case are, right? Because if the dispute is very technical and it uses certain industry terms, for example, or relies on certain practices, then you don't want your arbitrator to be unqualified to actually deal with that.
Yeah, I think super specialization is also something that, we see in Singapore first and then sort of trickles down down to us in a few years. Should be your take on this? How do you choose your arbitrators? And if you could also give us a domestic standpoint, because that's...
Yeah, absolutely. I think when it comes to the domestic standpoint, of course, the first thing you look at is, are you in arbitration with a private party or a government entity? Because that plays a big role as to, who you appoint. Uh, I think technical expertise, I couldn't agree more, Mahesh. I recently had a arbitration which was an oil and gas, very technical arbitration. I feel like I only probably understood the technicalities myself when we were finally going into final hearings. Uh, it was very technical, and the tribunal did struggle. And because this was a situation, where an expert had to be appointed for a certain determination, but parties hadn't done so, uh, they did find it very difficult to sort of do this adjudication themselves. So, in certain sectors, it is always good to have someone who has some sort of understanding of the industry. Sometimes we've even gotten recently an interesting query from clients where they're like, hey, how about, if it's a 3-member tribunal, both sides appoint their nominee and then let the presiding officer be somebody who's just technical, like he's the technical expert actually. And in some cases that also, could actually save a lot of time and costs as far as parties are concerned.
Yeah, but then I have my doubts as to the adjudication process. It'll get very difficult in that case. But that's interesting.
I mean, you have two judicial members in that sense who will, assist the presiding officer in that part of it. And then they're not at sea when the technical part of it comes. So, together, if the tribunal can work, and it has to be a very carefully constituted tribunal, it could actually, go well. And now, of course, sorry, go ahead, Mahesh.
No, Shruti, sorry, please go ahead. Sorry to
I was just saying that the other thing that we are seeing change in the domestic arbitration is that it's not just retired judges any longer. I mean, that is changing in such a big way. And not only are institutions working towards this and have made this a reality, but courts are on board today. The Delhi High Court, Bombay High Court, Calcutta, Bangalore, the big high courts, they are all appointing, practicing, advocates who they know are involved and know arbitration well. So a lot of people are getting the opportunity to also be arbitrators. It's important to note that that practice has changed. So we're looking forward to more of this, of course.
Yeah. Mahesh, you were saying something?
No, I thought there was an interesting practice in a dispute that I was involved in recently that dealt with the question of ICO, right, an initial coin offering, and it basically dealt with this question of whether or not that particular cryptocurrency is at risk of being considered to be the issuance of securities under American law. So the institution actually appointed a corporate lawyer that has advised regularly on ICOs, but with zero disputes experience or background for that matter. But the arbitrator was then assisted by a tribunal secretary who was a senior associate from the arbitration department in the same firm, which I thought was a very, very interesting mix. And it worked out really well because when we went in, we didn't have to explain to her all the basic ICO. We just went straight to the particular issue as to, whether the specific facts, contravened U.S. securities law or not. So I thought that was a pretty commendable practice that was, I think, initiated by the SIAC.
Oh, that's very interesting. Very interesting. And we have an institute here in India. It's called the engineers. I'm forgetting the full name. I'm sorry. I think it's called Engineers India or something, and they do this when they have technical disputes, especially on construction and delay issues. And I think the tribunal then is also two judicial members and one technical, which they appoint as their president. So very interesting. I think that's pretty commendable also from the SIC for creative thinking. I will like to now move on to, sort of the notice and slightly, like an interesting aspect when you do end up sending notices of arbitration. So, Mahesh, there are situations, when a contract is sort of also, supplemented by another contract, not entirely novated, but you have supplementary agreements in place. Uh, we have seen situations where there are dispute clauses in both the contracts. Um, what is your approach when you do look at contracts like this? Because there may be a case where one single notice will have to be sent initiating arbitration, uh, uh, you know uh, for different sort of disputes, or is it a case where you need to send two notices of arbitration where there are two contracts involved? So how do you look at it, the question of supplementary contracts and make main agreements?
Yeah. So that's an interesting question because you have, I think the question as to whether you are invoking one arbitration or two, it's a question of contractual interpretation. So if there's a main contract and then there's an amendment, if you construe it appropriately, the amendment may just be governed by the dispute resolution clause as provided for in the main contract. Or it could be two separate parallel contracts. They might appear to be very similar, but they have different, they may have their own independent arbitration agreements. So I think you should look carefully at the rules. For example, the LCIA rules actually provides that if the claimant wants to commence more than one arbitration under the LCIA rules, you can serve a composite request in respect of all the arbitrations, and then provided you meet certain requirements, right, and you pay the appropriate fee for the dispute. But I think it's important to get this right because you have certain cases where I think under some certain old rules, it was held that if you commence two arbitrations using a single notice, then it may be invalid, right? Most famously in this case called A and B under the old LCIA rules.
That's correct.
And then you also have the English decision of Agarwal Corporation, which also considers the question of whether you need to have a
So if I remember correctly, I think Agarwal was also when there were multi-parties involved, and I think they sent out one notice instead of two separate notices. So it was one arbitration instead of two arbitrations, and I think they struck it down.
Yeah. So I think it is quite important to get that right because eventually you want to avoid an unnecessary fight on your hands, right? And I think then that also lends itself quite nicely to the discussion on if you're trying to consolidate two arbitrations, whether clauses are compatible or incompatible for that matter. Do you have two arbitration notices and then apply for consolidation, or do you just combine both of the arbitrations into a single notice, but make it clear that two separate arbitrations and you are making the application in that single notice, right? So these are interesting.
You've asked the question on my account, so I'm going to ask right back at you. What about you?
I think, Mahesh, the safe answer you can say is it depends, no?
I was hoping Shruti is going to answer that. So,
Well, I'll tell you from an Indian perspective, it depends how you or your client wants to play it. Obviously, if you are the claimant and issuing the notice, you want to run one arbitration under, most probably, you want to run one arbitration under both the agreements. In which case, from an Indian perspective, you need to sort of determine what the parent or the primary agreement between the two is, where it is possible. And then invoke it under that. And then, make it clear in the notice why you are invoking under that, but how it is the parent. Of course, from the notice itself, you're going to have a fight on this all the way till the set aside. You know that, so it's best to be prepared. But this is also a very interesting thing about when you are issuing the notice of arbitration, Mahesh. Is that a good time where you intend to actually involve a third party, a non-signatory to the arbitration, and you know that you're going to include them in the arbitration? Is it a good idea in your view to sort of name them in the notice, issue a notice to them?
a third party to an arbitration, ordinarily the tribunal will have no jurisdiction, right? Unless the third party comes back and gives express consent to be joined to the arbitration. So I think if you want to involve the respondent and the third party, you should probably name the third party and see. It's better to know early on, right? And if you form of court relief to join them, then at least that's something that you can do. Interestingly, under the new SIAC rules, or perhaps even the previous edition, there are various options. You can file a notice in each separate arbitration and then later on apply for consolidation, or you can file a separate notice for each of the arbitration at the same time and concurrently apply to consolidate, or you can file a single notice for all the arbitration agreements invoked, and the notice itself is deemed to be an application to consolidate. Right, so all three options are actually possible. It depends on what you want to do.
Thanks, Mahesh. That's interesting. And Shruti, I think this also then ties down to the latest High Court decision in Delhi, which did say that the tribunal now has the power to sort of, even if I name them in my NOA and my arbitrations going on, I think under 17, a tribunal can add even without court intervention. So that's interesting. If I do mention the party in my notice of arbitration, then it sets the tone for how the tribunal must sort of take that.
Yeah. And this, Mahesh, I mean, this comes from that whole Cox and Kings, and now how Cox and Kings is being interpreted in courts. And in parallel, interestingly, on the appointment of courts, power of courts to appoint an arbitrator, how much interference can courts do? So those two positions are actually running parallelly, where now we know that a non-signatory could be bound in limited circumstances to the arbitration. But courts in a Section 11, we know, are putting their hands up to say, look, as long as I see there's a dispute, it's from a legal relationship, there is a valid arbitration agreement, the rest is all to the tribunal. So because both these positions happen to be running parallelly, so now it's all up to the tribunal to sort of decide, as I think it should be also. Because earlier in the Section 11, you could take these sort of arguments to say that, look, I'm a third party, I've received a notice to my name, there is no valid arbitration agreement. But now I think it all goes to the tribunal.
That is an interesting aspect, I think, of Indian jurisprudence, right? The group of companies, whether you can rope in non-signatories or not.
Right. Fantastic. So those become interesting aspects to consider when you are also drafting your NOA. Probably a good idea to consider it when you're looking at adding third parties. So I think we are coming to an end of this discussion. I did want to touch upon a lot more things, but I think we are running out of time. I will, however, ask both of you to sort of just quip in. Shruti, probably we can start with you, and Mahesh can have the final say. Any war story you want to set out for our listeners on a badly drafted notice of arbitration that sort of played out? You did mention there was something where, it was not sort of, the arbitration wasn't invoked, but anything else you would like to say before we sort of wrap up?
I mean, of course, anything bad that I've received has always been received. Let's start with that.
Yes, as all of us have.
Yes, absolutely. Never made a mistake in our lives. Never. But really, I think, in terms of war stories, yes, there have been a few, where in the notice of arbitration, party suddenly decides, the party invoking decides that it does not, in fact, want to have the seat that is mentioned in the clause, and, or change the number of arbitrators or strange things like that, leads to a lot of unnecessary headache and costs as far as respondents are concerned. But broadly, I think I'm just going to say that keep it simple. Don't overthink the notice, because I think Mahesh said this quite rightly, that you need to give yourself enough wriggle room. Generally, across the world, at the stage of issuing of notice, you don't know your case very well. And neither does your client at that point. They think they have an opinion, they think they have a case, but till you haven't seen it for yourself, nobody knows. So keep it as broad-based as possible. Don't go too much into the specifics. And even in terms of quantification, Mahesh, I don't know, I have started seeing that it's just a very broad sort of open-ended quantification. Of course, all rights reserved, but parties are lesser and lesser inclined to sort of state that number as is, and then in addition, if I have something else, we're going to bring it up to you. I don't know if you see it the same way.
Yes. So I think for the quantification aspect, these days the institutions desperately want to know because they want to fix your advance on fees. So that's something that if you refuse to quantify it, they will come back and try for two reasons really, not just the advance on fees, but also to see whether it moves into the expedited procedure track, right? Because the quantum of dispute may be below 6 million under the old SIC rules and below 10 million and below 2 million under the ICC rules. In terms of war stories or past experience, I mean, I have seen situations where an overly detailed notice of arbitration has gone very badly because certain positions that were taken in a very lengthy notice of arbitration, I think 50 odd pages, and later on the claimant tried to walk back on some of those positions, and those positions were very favorable to the respondent because there were multiple contractors, and in notice of arbitration, certain facts were actually set out which were not really in favor of the claim that was being brought. So and even though the hearing itself was 18 months away from when the statement of claim was actually filed, each time we were harking back to what was actually said in the notice of arbitration, and we were asking the main witness, did you give instructions on this? So it can sometimes be used to the strategic advantage of the party receiving it, and also in one instance the arbitration clause was extremely badly drafted, and the claimant then took the position that the seat is Singapore, the governing law is Singapore law, and the arbitrators shall be 3 arbitrators, even though the arbitration agreement did not set that out. And then the respondent replies saying, we agree to all of that. And later on, the claimant wants to change their position by saying that, no, actually, this is not a Singapore dispute, so we don't want Singapore to be a seat. And that's not what parties impliedly chose, and seeking to walk back on those positions. So I think it is a brief document, but it is the first salvo in a long set of proceedings. So it's quite important to get it right.
Perfect. Yes, I would agree. I think it's very important to keep it really, really short. We've taken advantage of, situations where, like I said, we've had composite notices being served to us. So those have a different aspect of what the breaches are, and the statement of claim ends up saying absolutely something different. So thank you so very much. I know there are a lot more things that we could have discussed in this first episode, but both of you have been really, really generous with your time and your comments. Thanks a lot for spending the time with us. Thank you, Mahesh. It's been an absolute pleasure, and we do intend to rope you in on further initiatives. It was an absolute pleasure to have you here on the podcast. Thank you, both of you.
Thank you to both of you. I learned something new as well. There's a composite notice of arbitration now.